Welcome to The Explainer. Look, if you're tuning in, you are likely gearing up to make a very real financial decision about protecting your product's design. Today, we're tossing out the generic legal jargon. Instead, I want you to treat this as a direct, insider consultation. We're looking at this through the lens of IP boutique law, drawing directly on the perspective of a former USPTO patent examiner. We're going to unpack exactly what drives cost variation in a design patent application right now in 2026. No filler, just clear, unhurried facts about what gets flagged on my old desk, what gets allowed, and where your money actually goes. So let's kick things off with a number that usually absolutely shocks first-time filers.
Now, what's really interesting about this is that $0 is the exact cost of maintenance fees over the entire 15-year lifespan of a design patent. Yes, literally zero. Once your design patent is granted, you never pay the patent office another dime to keep it alive. This is a massive, massive departure from utility patents, which, frankly, bleed you with mandatory maintenance payments for decades. What this means for your business strategy is profoundly simple. With a design patent, the upfront cost you pay is largely the total cost you will ever pay. So, knowing exactly what goes into that upfront cost, well, that's absolutely crucial for your IP budget.
Here is our roadmap for today's consult. We're going to start with the true upfront cost. Look at how your business size sets your baseline. Navigate the examiner's drawing trap, assess prior art risk, contrast this with utility patents, and then finally, build out your all-in budget.
Section 1. The true upfront cost. What you pay is what it costs.
Because design patents carry no maintenance fees, they're highly cost predictable. Your initial investment is essentially your total investment. For most inventors and businesses, a design patent is going to run you somewhere between $1,600 and $4,500. All in. That's the whole shebang. It covers your USPTO government fees, the cost of professional drawings, and your attorney's fees from that initial filing all the way through to the notice of allowance. But, a nearly $3,000 spread is a pretty wide margin, right? Well, where you land in that range isn't just random. It's dictated by three very specific variables: your entity size, the complexity of your design drawings, and whether the patent office kicks back a rejection. Section 2. How entity status dictates fees. Setting your baseline at the USPTO.
Okay, let's dive into this. Before you even hire an attorney, your business size immediately dictates the baseline fees you're going to pay directly to the United States Patent and Trademark Office. Notice the physical drop here based on entity size. This covers everything from filing through examination and final issue. If you're a large entity, the government takes $2,600 right off the top. But if you qualify for small entity status, which applies to independent inventors and most businesses with fewer than 500 employees, that fee drops to $1,040. And if you actually meet the income requirements for micro-entity status, your government fees plummet to just $520. Qualifying for micro or small entity status is a critical first step. It slashes your baseline government fees by up to 80%. That keeps vital capital right where it belongs, inside your business. But government fees are really only part of the equation here.
Section 3. The examiner's drawing trap. The #1 pitfall for applicants.
I want you to shift your perspective for a minute and look at this right from the examiner's desk at the USPTO. Applicants consistently assume that high costs come from endless attorney hourly billing. But from the inside, we see that the biggest driver of unexpected cost variation actually traces back to drawing quality. So the absolute crucial point is this strict legal standard from the Manual of Patent Examining Procedure. It demands a complete disclosure of the appearance of the design. See, in utility patents, your written words define your invention. But in design cases, the drawings aren't just helpful illustrations, they are literally the entire claim. If there's any ambiguity, any missing angle, or any improper shading, the examiner has no choice but to object. And when they object, you pay your attorney to fix it.
Let me tell you exactly what gets flagged on the examiner's desk. These are your immediate rejection triggers. Using solid black shading on a 3D surface instead of proper stippling. Showing the surrounding environment in solid lines instead of broken, dashed lines. Having a curve in the front view that for some reason mysteriously disappears in the side view, or entirely omitting required orthographic views. Now, these might seem like minor technicalities, right? But they are strict USPTO rules. I can't even tell you how many times I had to kick back an otherwise brilliant, innovative design just because the shading was solid black instead of stippled. It's heartbreaking, really, because it delays the allowance by months. Worse, dealing with these easily avoidable drawing objections, that's going to cost you between $500 and $1,500 in attorney response time.
Now, stepping back into the role of your strategic counsel, the solution here is incredibly straightforward. Invest $300 to $800 upfront. That's the typical cost to hire professional patent illustrators who have specific USPTO experience. General graphic designers or cheap foreign drafting services consistently miss these strict shading and line weight standards. Paying a few $100s for specialized patent illustrators on day one is, for sure, the absolute best way to avoid a $1,500 drawing trap later. Do it right the first time, and you neutralize the biggest risk to your budget.
Section 4. Navigating prior art density. Assessing your risk for substantive rejection. All right, so we've controlled for government fees and drawing quality. The next active risk variable is your industry. Historically, design patents enjoy a fantastic allowance rate of roughly 85 to 90%. Most of them sail straight through without a substantive rejection. But what about the other 10 to 15%? Well, the likelihood of hitting a roadblock depends heavily on the crowdedness or density of your specific industry. From our experience examining applications, we know exactly which categories see the most prior art rejections. Consumer electronics, furniture, and apparel accessories. They sit right at the top. The prior art landscape in these spaces is incredibly dense. If your product is in one of these categories, you're at a higher risk of the examiner finding a similar existing design. If you do get a prior art rejection, it'll cost roughly $1,000 to $2,500 in attorney time to carefully argue against it and strategically amend your claim.
Section 5. Design versus utility costs. The long-term maintenance burden.
And this brilliantly illustrates our next point. We've talked deeply about the costs of a design patent, but it's absolutely crucial to understand these numbers in context. There is a stark financial contrast between these two paths. Looking at a design patent, you're looking at $1,000 to $2,000 in attorney drafting fees, because the structure is simple. It's just one claim driven entirely by the drawings. And, as we established, zero maintenance fees. Compare that to a non-provisional utility patent. Attorney drafting fees absolutely explode to between $4,000 and $12,000 or more. That's because of the complex technical writing and multiple claims required to define the invention. Then comes the real long-term burden. Utility patents require punishing maintenance fees at 3.5, 7.5, and 11.5 years. That can easily add another $800 to over $7,000 just to keep the patent alive.
Section 6. Your final all-in budget. Mapping the real-world scenarios.
Let's move to and see how this builds. We've synthesized all the variables: entity status, drawing quality, and prior art risk. Now let's map out the scenarios. This gives you clear expectations based on IP boutique law rates combined with government and drawing fees. If you're a micro entity with a clean application, you're looking at roughly $1,800 to $2,900 total. But let's highlight the most common scenario: an independent inventor or small business filing as a small entity who submits perfect drawings and faces no office actions. That lands very comfortably between $2,300 and $3,400. Now, if you do hit a dense prior art roadblock, you can see that budget stretches to between $3,300 and $5,400.
One quick note before we conclude, and kind of think of this as a helpful footnote from your attorney just to ensure there are no surprises down the line. You should budget for specific strategic extras if your business model demands them. For example, if the examiner forces you to split multiple designs into separate applications, you'll pay for what we call continuations. If you want international protection through WIPO, the Hague Agreement is going to add $1,500 to $4,000. And if your product launch demands a patent in under 12 months instead of the standard 14 to 20 months, you absolutely must budget an extra $700 to $1,000 for the USPTO's expedited rocket docket.
Which brings us to our final thought. Is your product's visual appearance your greatest competitive advantage? Utility patents protect how something works, sure. But if competitors are most likely to copy your product's distinct look, a design patent is your best weapon. For around $3,000 upfront and absolutely zero maintenance fees over the next 15 years, securing a monopoly on your design is often the single most cost-effective intellectual property strategy a business can execute. Think about your product, think about your competitors, and ask yourself, is securing that look worth the investment?